Last night at the Hardwinston Lodge, the university sponsored its third in the series titled Conversation on Law and Society. And the theme for last night's presentation was the constitutional guarantees of the fundamental rights of citizens. The featured speaker was Justice Carl Singh, and he spoke a lengthy presentation, but it was well received by those who were gathered here. Take a listen.
This freedom of expression is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb the state or any sector of the population. The European Court has expressed the need for special protection for those who attempt to question and criticize government and public officials, insisting that persons in public offices should demonstrate tolerance in the face of criticism. In this case, the government issued orders prohibiting the importation of newsprint and printing equipment except by license granted by the competent authority. The respondents were the publishers of the Mirror newspaper. They challenged the orders on the ground that it hindered their freedom to disseminate information and ideas through their newspaper. In the view of the Court of Appeal, the state had the right to take action to conserve scarce foreign exchange, and it was too sad if, in the process, the applicant was prejudiced. This was a political rationalization. It is difficult not to feel a tinge of suspicion over this direct impact theory, which runs counter to all principles governing the interpretation of a constitution in a generous and purposive way. Dr. Makepeace Richmond was the chairman of a political party known as the Liberator Party. He presented to the Guyana Chronicle a paid advertisement by his party giving notice to the public of the venue and time of a public meeting to be held by his party. The Guyana Chronicle refused to publish the advertisement. The case is known as Richmond versus Guyana National Newspapers Limited. Richmond's case was that the Guyana Chronicle had been willfully and maliciously refusing to publish in their newspapers the views of opposition parties, while in pursuit of a settled policy of discrimination. It had been fully and comprehensively publishing the views and activities of the government of the People's National Congress. Justice Bishop, in his ruling, said that the Guyana Chronicle, quote, being sensitive to the control and supervision which the People's National Congress government had over them by virtue of the obvious rigor of the provisions of the Public Corporations Act, became a willing instrument of the party and government. The treatment which they accorded to the People's National Congress was noticeably different to that meted out to the political parties or groups opposed to the Constitution Amendment Bill, the refusal of which the applicant complains has been proved beyond any doubt.
It's a pity we couldn't carry the whole segment of what took place there at the Hardman-Stone Lodge last night. However, we will put it on the website, George. But you get an idea of what took place last night. Very riveted presentation that engendered a host of questions. The question and answer period went well over an hour last night as folks sought to some to objectively ask questions of the Chancellor, and some wanting to seek to put the Chancellor on the spot. And back to you, George.
Thanks for watching Channel 2 Headline News. If you like this story, leave a like. We'd really appreciate it. Also, you can share your views and comments below. And if you really like what you see, hit the subscribe button for updates on all the news happening in Guyana.